Distinguished delegates, ladies, gentlemen, my colleagues from RV and their students. On behalf of RV University, it is my pleasure and privilege to welcome all the distinguished guests and participants to the India-US Law and Justice Forum, the role of judiciary in protecting the rule of law and promoting success to justice today. We have gracious presence of Dr. A.V.S. Murthy, Chancellor, RV University, Chief Guest Honorable Mr. Justice R.V. Ravindra, former Judge. Our distinguished guests from US, our guests from O.P. Jindal Global University. To proceed with the forum, let me invite our Honorable Founding Vice Chancellor, Professor Dr. Y.S.R. Murthy, to welcome for his welcome address.
Good morning. Chancellor RV University, Dr. A.V.S. Murthy, esteemed Chief Guest, Honorable Mr. Justice Ravindran, former Judge Supreme Court of India, all 9 distinguished judges and a distinguished academic from the US delegation, JGU Vice Chancellor Professor Rajkumar, principals of various law colleges in Bangalore, senior partners from various corporate law firms, my colleagues from the School of Law, RV University, and dear students, I wish to extend a warm welcome to each one of you. I wish to say a few words about our chief guest. Honorable Mr. Justice Ravindran has had an illustrious legal career spanning over 6 decades. During his 6-year stint as the Supreme Court judge, Mr. Justice Ravindran delivered several landmark judgments on constitutional law, reservation for other backward classes, and education. He was part of a 5-judge bench that upheld a 2006 law providing for 27% reservation for other backward classes in central educational institution while excluding the creamy layer from the purview. While in Karnataka High Court and later in the Supreme Court, his work on legal aid is remarkable. Post-retirement, he served as chairperson News Broadcasting Standards Authority for 6 years. He authored a book called Anomalies in Law and Justice that brings forward contemporary problems in justice delivery, corruption, loss of confidence of the common man in the rule of law, judicial conduct in decision making, and law not being in sync with justice. Mr. Justice Ravindran has been described as one of the greatest judges of the Supreme Court by former Chief Justice of India, Mr. Justice Kapadia. We are delighted to have him in our midst today. Rarely do we get a galaxy of 9 Supreme Court and other court judges from US together in one platform and a distinguished academic from the University of Hawaii. We are truly privileged to have you in our premises today. A warm welcome to each one of you. Parent sponsoring body, Rashtriya Shikshana Samiti Trust, has a rich legacy of 84 years of excellence in education. It has established 25 academic institutions in which over 25,000 students are currently enrolled from kindergarten to PhD level. Nearly 400,000 students have already been graduated so far in the past 8 decades. I wish to extend a warm welcome to our Chancellor and Secretary of the Trust, Dr. A.V.S. Murthy, who has been leading and directing this effort over the past 5 decades. The vision of our RV University is to be a world-class, tech-driven global university for liberal education. Into its 3rd year of our operation, it has already established 7 interdisciplinary schools in which over 2,300 students are currently enrolled in 60 degree programs. The School of Law, RV University, is delighted to partner with O.P. Jindal Global University and in particular with my mentor and dear friend, Vice Chancellor Professor Rajkumar, in organizing this important seminar on the role of judiciary in protecting the rule of law and promoting access to justice under India-US Law and Justice Forum. This forum promises to open up a lot of possibilities for intellectual exploration. It will focus on law and judicial review in a comparative perspective and also assess the challenges to rule of law and access to justice. We also look forward to further collaborations with the visiting delegation. I wish to acknowledge the presence of representatives of several law firms and academics here. We have Dr. Anjina Reddy, Principal RV Institute of Legal Studies, Professor Mallikarjunayya, Principal KLE Law College, Dr. Uma Mahesh, Principal Ramaiah College of Law, who is going to join us shortly, Ms. Ashita Bhagavan, Managing Partner, Inventus Law Firm, Mr. Neeraj Dubey, Founder and Managing Partner, Valley Points, Mr. Siddharth Raja, Senior Partner, Vertis Partners, Ms. Namrata Kolar from Cyril Amarchand Bangaldas, Mr. Santanu Saha, and many others. I wish to extend a warm welcome to each one of them. We look forward to productive deliberations. Thank you.
Thank you so much, sir. Now, I would like to invite Professor Dr. C. Rajkumar, a founding Vice Chancellor of O.P. Jindal Global University, for his introductory remarks.
A very, very good morning to all of you. First of all, I would like to recognize the presence of our very distinguished judge, who I have known for a very long time from distance, and my father has also has had the opportunity to be aware of his work and work with him as well. Honorable Mr. Justice Ravindra, thank you very much, sir, for your distinguished presence here. We couldn't have found a more appropriate person to set the stage for today's proceedings, especially when we talk about the need for protecting the rule of law and promoting access to justice. I want to thank and appreciate the contribution of the Chancellor, Dr. Murthy himself, the kind of keen interest that he has taken along with his colleagues to not only build this institution but also to nurture it and to take it to the stage where it is. So, congratulations, Dr. Murthy, for your contributions. Thank you so much. Of course, I'm so delighted to see my friend, Professor Murthy, who I miss every day at our campus. I would like to consider him as our gift to RV and to and it was so good to see Lakshmi Arya was also a former colleague of mine, and Emlata and so many others, friends here. Good to see Siddharth. This forum is an amazing effort that I think we call the India-US Law and Justice Forum. Somebody asked me what it is. I said it was just a figment of my imagination that I created 2 weeks ago. There is no such thing, but we've just created it. Now that we've created this India-US Law and Justice Forum, we have an opportunity to do many more things under it, and this visit of this extraordinary group of 10 judges and jurists from the United States to India has provided a new impetus to bring us together in more substantive ways. I want to begin by saying that one of the remarkable things about the United States is that the openness in which that country and its institutions have always collaborated with institutions and universities around the world. I want to share our own experience. Long before, when I had the idea of building this university, when I was a student at Oxford in 1998 and later at Harvard in the US, I began to interact with a lot of friends of mine and my teachers and mentors. And can you believe it that when I set up this international board of advisors of this non-existent university way back in the year 2002, I had people like Anne-Marie Slaughter, who was the dean of the Woodrow Wilson School of International Affairs, and some 20 other professors from Harvard, Yale, Columbia, NYU, and Michigan and Cornell. And they believed in the idea of institution building. I can even trace back to the early history when Indian Institute of Management, Ahmedabad, as well as other leading Indian institutes were set up. The top American universities, including Harvard Business School and MIT, were deeply involved in it. So I want to begin by saying that this visit of the 10 judges and jurists from US is part of the larger continuum of engagement between two democracies with shared values, two democracies which have deep commitment to the rule of law, two democracies which are extremely complex and are also facing challenges relating to both rule of law and access to justice. I also want to mention that these 10 individuals represent 5 different states of the United States. They are from the state of Hawaii, the state of New York, the state of Illinois, the state of California, as well as the state of Oregon. And they also represent different levels of the American judiciary, including the federal court, the state court, as well as the Supreme Court, which is the highest court within a state as well. Amongst that group, we also have a very distinguished academic who has been a serial dean. She has had deanship in many law schools in the United States, and now she's dean of the University of Hawaii, William Richardson School of Law. I also want to mention that I am personally very delighted to be here. I should tell Professor Murthy that when I spoke to Professor Murthy in putting this together and we saw the program, I had 2 of my old friends who are leading, one is 2 of them vice chancellors in other universities in India, one public and another private, and called me and said, Raj, you have all these visitors coming, but why would you take them to another university so that they will also get to know them, and isn't it not undermining your own effort? And I started laughing, but then I realized why this person had asked that question, because in India, and unfortunately, many of these institutional opportunities seem to be monopolized by few institutions on the one hand, and also seem to be something that should not be shared. And so we at our university have been very conscious from our founding that we want to democratize and make these opportunities more inclusive. So it has always been our endeavor that when we have individuals and institutions connect with us, we make it a point to connect with other similar like-minded institutions which have shared values. RV University, under the dynamic leadership of my friend, the Vice Chancellor, Professor Murthy, has nothing but one such institution that we want to work together. So I'm personally delighted that we are able to do this jointly. Lastly, I want to say that for this forum itself, it has brought together people from different constituencies. We have lawyers representing law firms, law professors representing various law schools, law researchers representing the faculty itself, and there are all obviously students who are present here. And that also speaks volumes about the relationship between law and justice and its wider implications for society. I also want to mention that we are doing this forum at a time when democracies are also facing internal and external threats towards fulfilling the vision for the rule of law. It cannot be assumed that if you are a democracy and that you have free and fair elections and you have a relatively independent set of institutions, including strong protections of freedom of speech and expression and freedom of media and other democratic institutions functioning well, you cannot assume that that will automatically ensure the protection of the rule of law, or for that matter will advance the cause of access to justice. Eternal vigilance is the price for liberty, and we need to constantly work towards addressing this challenge. And so today, and this effort has been part of our journey to be able to recognize this role. I want to quickly end by saying that the distinguished judges and jurists from the US began their journey in Delhi 4 or 5 days ago, started with a trip to the Taj Mahal, and that was the only thing that we did which is non-deeply taxing and engaging in terms of their academic and intellectual work. After that, they began a series of meetings and interactions with several judges of the Honorable Supreme Court of India, as well as senior counsels and others in Delhi. That was followed by a visit and spending an entire day at our campus at Jindal, where they interacted with our students and faculty. Our students and faculty were deeply inspired by their commitment to the cause of rule of law and access to justice. Followed by that, we also had a visit to the Rashtrapati Bhavan, and then we landed up in Mumbai. We spent an entire day in Mumbai. We had a fantastic roundtable and symposium at a leading law firm called Sriramachan Mandradas in Mumbai. That was followed by a visit to the Bombay High Court, where we had widespread interaction with the Bombay High Court's lawyers and worked with the two associations there, both the Bombay Bar Association as well as the Association of Lawyers of Western India. We also visited the Bombay High Court's museum, and then that was also followed by a very truly inspiring experience of interacting with the Chief Justice and the 35 plus Bombay High Court judges. The Chief Justice of Bombay High Court was very generous to bring the entire court to host us and provide an opportunity to engage with them. That led us to moving into Chennai. We spent an entire day in Chennai yesterday, starting with the round table at Surana & Surana, another law firm there, followed by an interaction with the lawyers at the High Court Bar Association, and then finally, towards the end, an interaction with the Chief Justice of the Madras High Court as well. Late last night, we reached Bengaluru, and today we are very fortunate that we'll be here at RV, followed by a similar interaction with the Karnataka High Court Bar Association, and later the Chief Justice of the Karnataka High Court will be hosting us in the evening, and then late this evening we'll be moving into Kochi, which will be the last leg of our trip, where we'll be doing a similar thing with the Kerala High Court. I wanted to say this because of the fact that I want to pay tribute to these amazing 10 individuals who have not only been able to participate in this excruciatingly painful schedule of meetings which last, say, from 7 a.m. onwards till midnight or sometimes more, but have been doing this with the spirit and the commitment and the dedication that people who are deeply committed to public causes can only have. For all the students and the relatively young people who are present here, it is truly remarkable and deeply inspiring for me for them to do this, and do this with the seriousness and the dedication with which I want to pay tribute and a round of applause. I can tell you that this trip is not for the weak-hearted, and none of them are.
I have to say, I don't know if any of you know the show Survivor. I just saw in our meeting earlier what Raj is going to do. He's been filming everything. And what you're going to do is a world-class documentary on survival. 10 judges from the United States who will go off the island first. But it has been extraordinary, and what a gift to be here. But I had to say, I was sitting here thinking, none of us are off the island. We're still alive and we're still here.
Thank you, Jalda. With those words, thank you very much, and deeply appreciate all of your questions.
Thank you so much, sir. Let me now invite our chief guest, Honorable Mr. Justice R.V. Ravindran, former Judge, Supreme Court of India, for his inaugural address.
Mr. U.S. Murthy, Chancellor, Army University, Professor Raj Kumar, founding Vice Chancellor of OP General University, Professor Y.S.R. Murthy, founding Vice Chancellor of OP University, Dr. Lakshmi Arya, and let me name each one of you. You have taken so much trouble to be here. Justice Michael Wilson, Justice Sabrina McKenna, Justice Todd Eddings, Justice Anne Aiken, Justice Jenny Rivera, Justice Sarah Ellis, Justice Josephine Staten, Justice Douglas Tukey, Justice Henry Bellot, and Professor Camille Nelson. Pardon me for any mispronunciation. I remember a movie about a European tour known as if it is Friday, it must be Belgium. you must remember that it is a Friday, it is Bangalore. Otherwise, Bangalore, Kochi, Chennai, it is a blur. But only thing is, we have the best of Bangalore has a very pleasant climate. We are very proud of it. And the worst traffic in India, that also we are very proud. We have something to share. Members of the faculty and students of School of Law, Army University, ladies and gentlemen, I take great pleasure in inaugurating this seminar conducted under the aegis of India-US Law and Justice Forum, which Professor Rajkumar said is a recently coined term or recently generated institution on the theme, the role of judiciary in protecting the rule of law and promoting access to justice, with the participation of distinguished judges from the United States of America as panelists. The theme of the first session is Judicial Review, Challenges and the Way Forward. The theme of the second session is Law in a Globalizing World, Challenges for the Rule of Law and Access to Justice. Dicey defined the rule of law as consisting of three principles. The first is the supremacy of law, that is, the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power, and excludes the existence of arbitrariness, of prerogative, or even of widely discretionary authority on the part of the government. A man may be punished for a breach of law, but he be punished for nothing else. The second principle is equality before law, that is, the equal subjection of all classes to the ordinary law courts. The third is the predominance of legal spirit, that is, no one, neither the government nor the citizen, is exempted from obeying the law and subjecting themselves to the jurisdiction of courts and tribunals of the land. It implies an absence of arbitrary power on the part of the government and government. Only a strong and independent judiciary exercising the power of judicial review carefully and responsibly can ensure equality of all persons before the law and prevent arbitrariness creeping in the exercise of power by the government and its agencies, and thereby establish the rule of law. Judicial review enables the checking and balancing in a democracy against executive excesses and legislative errors. The concept of separation of powers put forth by Montesquieu and generally followed in USA under its constitution requires each wing of the government to exercise power falling under its area, and neither wing should exercise any power which falls within the domain of the other two wings. On the other hand, the Indian Constitution, though federal in structure, is modelled on the British parliamentary system. In India, no wing of the government is considered supreme, all being creatures of the Constitution, which is supreme. No wing of the state is conferred with absolute authority or unlimited power, nor primacy over the other two wings. The doctrine of separation of powers in the context of the Indian Constitution is neither absolute nor strict. Therefore, there are more chances of the judiciary straying into the domain of the executive and domain of the legislature in India more than in United States. Equally, there are more chances of the executive encroaching upon the fields of the judiciary and the legislature in India. The power of judicial review, however, is put to test in three circumstances. The first is when the executive amasses power in a particular person or persons, a group of persons, to create an authoritarian regime and attempts to undermine and weaken the democratic institutions, and in that process attempts to curtail the power of judicial review. The second is when the citizens develop apathy towards the pain and suffering of others and start believing that the individual rights or minority rights are of no consequence, or at all events they should be subservient to the right of the majority. The third is when judiciary itself, either with misplaced enthusiasm or an erroneous notion of the extent of the nature of its powers, frequently overstretches its role and strays into the domain of the legislature and executive, making governance difficult. The problem in India arises out of a peculiar situation where the Indian Supreme Court, instead of operating as a single unit with a single voice, operates in divisions of 2 or 3 judges, thereby virtually functioning as 13 or 14 Supreme Courts, speaking with different and many a time with inconsistent voices. On the other hand, the American Supreme Court, whether loaded with Republicans or loaded with Democrats, speaks with one voice. The American Supreme Court, like any other court, may sometimes get things wrong, but they are clear about it, thereby avoiding confusion and chaos. In India, we have to find a way to ensure that there is unity and clarity about what the Indian Supreme Court speaks and declares. The absence of a single voice has led to the peculiar position where there is a tendency to review the law laid down by even constitutional benches immediately after the leading member of the bench retires. Frequent changes in law declared by the Supreme Court is not good for the country. I am tempted to recall what the great Justice Cardozo said more than a century ago as to what judges can do and cannot do. I refer to the quotation from Nature of the Judicial Process. I quote, "The judges have the right to legislate within gaps, but often there are no gaps. We shall have a false view of the landscape if you look at the waste spaces only and refuse to see the acres already sown and fruitful." I think the difficulty has its origin in the failure to distinguish between right and power, between the command embedded in a judgment and the general principle to which the obedience of the judges is due. Judges have, of course, the power, though not the right, to ignore the mandate of a statute and render judgment in despite of it. They have the power, though not the right, to travel beyond the walls of the interstices, the bounds set to judicial innovation by precedent and custom. Nonetheless, by that abuse of power, they violate the law. If the judges remember the distinction between right and power and resist the temptation to interfere in matters of policy or to formulate policies and use the power of judicial review to nudge the executive to do its duty rather than take over the functions of the executive, judicial review will be meaningful. Let me share a few thoughts on access to justice. If the poor and weaker sections cannot go to police for fear of being ignored, harassed, or being falsely implicated, and if they cannot approach courts for want of easy access, then they do not have any effective forum to ventilate their grievances. That leads to resentment, helplessness, anger, and frustration, which is dangerous mix that can erupt into sudden and serious violence. Those subjected to injustices and not having access to justice become easy prey to calls for terrorism, militancy, anarchy, insurgency, and vigilantism, tearing the very fabric of democracy. Anyone denied justice and equality when not able to access effective and speedy justice may tend to take law into their own hands, leading to increase in crimes. Indian judiciary, in particular the district judiciary, by tradition follows the British system where the judge is considered to be a neutral umpire who is not expected to investigate into truth but merely consider the evidence placed before him or her, hear the argument, and then decide in favor of one who has made out a better case. Of course, in an ideal adversarial litigation where the parties are evenly matched and are represented by competent lawyers, it may be proper for the judges to merely sit, listen, and watch, being sure that truth and justice will ultimately prevail. But what happens where the dispute is between a rich and powerful on one side and a poor and downtrodden on the other? What happens when the litigation is between the helpless citizen on one side and the mighty state on the other? What happens if the persons in power act against the interests of the government for personal gain and practice nepotism? What happens if the persons who come knocking at the doors of the court belong to a weaker or marginalized section of the society who do not have any resources to fight? What happens when a tribal who has no idea of rights and obligations is catapulted into fighting a scheming land grabber or a ruthless loan shark or a mining baron or an insensitive and non-caring government? Should the judges keep quiet and watch when the interests of the poor and weak are mauled and destroyed? Should the judges merely sit and watch when a false and trumped-up cases are brought by the police against an innocent, or when the rich and powerful cover up their misdeeds and draw red herrings with the help of unscrupulous lawyers? Should a judge sit and watch when sabotaging of a criminal case begins from the very stage of registering the complaint and the basic evidence is not presented by the prosecution? Is it not the duty of courts to not only do justice but also ensure that justice is done? When courts alone can provide a level playing field for the poor, downtrodden and weaker sections to challenge or take on the rich, powerful and mighty, it is for the courts to ensure that the citizens have access to justice. In India, the Legal Services Act enjoins the legal services authorities to render to every poor and disadvantaged person legal services for the conduct of any case or legal proceedings before any court or tribunal. The legal service authorities at national, state, district and taluk levels are controlled and administered by judges. Unfortunately, those availing legal services are not satisfied with their quality either due to the fact that legal aid counsel are not competent or due to lack of choices of counsel or due to non-friendly or unhelpful attitude of officials of the legal service authorities. The United States and Brazilian models rendering legal services is worthy of consideration. I understand that in the USA, the Public Defender's Office, which is an agency well funded by the government, provides legal representation to indigent accused by assigning lawyers or to defend the accused. The Brazilian Public Defender's Office, extending legal services to the indigent, is independent of all three branches of the government. The Indian Supreme Court, of course, has shown its commitment to provide access to justice in various forums by adopting several commendable initiatives, from instituting live streaming of proceedings to democratizing access to justice for lawyers and litigants alike through virtual proceedings. The e-courts project of the Supreme Court, which is currently in phase 3 of its operation, aims to achieve the following. Firstly, enable any litigant or lawyer to file a case from anywhere at any time without having to go to multiple windows in the premises of a specific court. Secondly, enable lawyers and litigants to effectively plead their cases with certainty of hearings through optimal hearings, video or audio, in person or in writing. Thirdly, build a smart system in which registries will have to minimally enter data or scrutinize files owing to foundational capabilities of data connected through leverage technology. And fourth, create a system that combines the vast body of judicial data to foster legal literacy and furnish information or remedies to an aggrieved person at the click of a button. The Supreme Court's recent permission to a deaf lawyer to appear along with a sign interpreter is yet another measure to widen the physical access to justice to litigants or lawyers, irrespective of their disabilities or challenges. The Supreme Court is also taking effective steps to popularize mediation and other alternative dispute resolution processes. Globalization and international trade and commerce led to the rapid growth of international law. Growing national sentiments, fueled by threats and dangers from hostile nations and conflicts between domestic law and international law, are straining and slowing down globalization and creating challenges to the rule of law. Seminars like this create great opportunity for free exchange of ideas and meaningful debates. I am sure that your discussions and deliberations today will contribute to finding solutions to the challenges faced by rule of law in a globalizing world. Thank you.
Thank you so much, sir. I would now request our Chancellor, Dr. A.B.S. Murthy, to felicitate our chief guest. request Dr. Lakshmi Arya, Dean Research and Associate Professor of Law, for a vote of thanks.
On behalf of RV University and OP Jindal Global University, the co-organizers of this event, I wish to thank our distinguished guests who are here today for the India-US Justice Forum. Honorable Mr. Justice R.V. Ravindran, sir, thank you for gracing this occasion as our chief guest and for raising significant questions about access to justice and rule of law with respect to disability, class and other parameters. Honorable justices and judges who are visiting from the US, such an honor to host you. We look forward to learning from you in the sessions to follow. Thank you for sharing your expertise, your experience and time with our faculty and students. I would like to thank the Honorable Chancellor of RV University, Dr. A.V.S. Murthy, for his guidance and support of all our endeavors. We are grateful to Professor Rajkumar, Honorable Vice Chancellor of OP Jindal Global University, for the generous partnership he has been extending to RVU and for making this collaborative event possible. I've had the privilege to work with Professor Raj before, and as someone rightly said, I am one of the progeny of GGU. Professor Dwarika Amyal, Pro Vice Chancellor and Director Minerva, and his lovely team, many thanks for hosting this event. I'm especially grateful to those of you who made it to today's event, principals of law colleges in Bangalore and senior partners of law firms. Thank you for accepting our invitation and for coming. Professor Murthy asked me to keep this short, but this note would not be complete if I did not mention him. His vision of internationalization, collaboration and pedagogy is behind this event. Indeed, it is at the core of his leadership of our university. My faculty colleagues from the School of Law, administrative staff, communications team, student volunteers are very promising young students who have worked very hard to ensure the smooth functioning of this event. Huge thanks to all of you. I now request Honorable Chancellor Dr. A.V.S. Murthy to kindly felicitate Honorable Mr. Justice Ravindran.
Thank you so much. Now it's time to proceed for our next program, Thematic Session 1, Judicial Review Challenges and the Way Forward. For the same, I would like to request our distinguished panelists, Honorable Mr. Justice Michael Wilson, former Judge, Supreme Court of Hawaii, Honorable Ms. Justice Sabrina McKenna, Judge, Supreme Court of Hawaii, Honorable Mr. Justice Todd Edens, Judge, Supreme Court of Hawaii, Honorable Judge N. Aiken, Chief Justice, U.S. District of Oregon, Honorable Judge Sarah Ellis, Judge, U.S. District Court of Natural District of Illinois, to grace the dais, please. I would also request my colleague Dr. Gitanjali Srikantan, Associate Professor, School of Law, to moderate the session.
A very warm welcome to our distinguished panelists. I'm very pleased to chair this session, and I would like to welcome all the delegates to this session, which is Judicial Review, Challenges and the Way Forward. The issues and questions for this session are as follows. What is the future of judicial review? How does one view the future of judicial review in light of populist governments interfering with judicial independence and restricting judicial oversight over legislation? How can judicial review ensure that there is no deterioration in the rule of law in light of such legislative measures? What are the challenges involved when constitutional design and institutional histories of courts hinder that capacity to perform the function of judicial review effectively? Judicial review has been tested by increased executive power during times of crisis such as the COVID pandemic. And how can judicial review function in this context without violating the separation of powers doctrine, and also ensuring that social and economic rights are not violated? What are the challenges in redefining the grounds on which legislation may be reviewed by the judiciary? Can comparative constitutional law be a source in addressing conflicts between judicial activism and a rigid interpretation of constitutionalism? I look forward to your contributions on this very important topic. I'd be grateful if we could restrict ourselves to 3 to 4 minutes for each session, for each speaker, and we can open up questions and answers from the audience. Perhaps the Honorable Justice Wilson could begin.
Aloha. Aloha. And this is the term we use in Hawaii that, like Namaste, recognizes the beauty in every human spirit. Oh my goodness, it's just such a magnificent day, and to see the work that one of my heroes, Dr. Murtry, has created. Thank you so much for putting this together with Raj. So, this is the coolest lei I've ever got. That's what we call it in Hawaii. But it makes me feel like I have to say something special, and now I have about 3.5 minutes left. So let me go to the special part of what we're talking about here. Miracle law. Justice Ravindran mentioned this idea of power versus right, or power versus justice. The idea that you get a chance to take the rule of law, we review it as human beings, as justices, and particularly if you're in appellate court, but you review it in what context? You review it in the idea of, are you going to go to the idea of power, which unfortunately corrupts, or right, the idea of justice? And getting back to miracle law, are there any miracles in this room? How many of you are the result of the survival of somebody that was evolved 300,000 years ago? How many of you? All of us. Our ancestors all survived long enough to produce a family, and we are the result of that family. And then the other miracle is brute force, war, the control of human beings through intimidation and fear. That is what? The normal history you would expect of humanity. But a miracle happened, this idea of the rule of law. And who gets to practice the rule of law? Strong democracies maybe, and what's the most powerful democracy in the world? Now it's probably India. Why? Because our Supreme Court has gone rogue. Our Supreme Court in the United States has gone towards power. Your Supreme Court, because of extraordinary what? I think, when you talk about the history of miracle law and justice, in India you think about freedom fighters. Listening to Justice Ravindran, I get the feeling of a freedom fighter. So, you law students now get, and this is so exciting to be able to talk to you, you get a chance to use the rule of law, more powerful at this point in history than a nuclear weapon. It's handed over to you with the tradition of doing the right thing, of paying attention to the underprivileged, of trying to protect your future, because you're looking, people here that are 40 years old and below, are looking at the most dire future you could have. In other words, climate change. You know, the threat to your future. Can you handle it? Of course. This is a miracle country. We are, in a way, in the United States, because we have some great judges. And I just want you to step back for a private moment and think about who is here. These are some of the greatest judges in the United States. Andre Barreau had the power of a U.S. attorney to prosecute, and now is somebody that's a leader in justice and rehabilitation. Every single judge you're going to see here, whether or not we're talking about the giants now of the law in the United States when it comes to climate law. My colleague Todd Edens, Josephine Staten, Ann Aiken, when you research their cases, you'll see this is the cutting edge of your future, the climate rights in the future. And it's something that gets fertile ground in India because of the nature of your law already under Article 21. The idea of right to freedom includes the right to a clean and healthy environment. You've got the fertile ground for justice and a miracle to protect you in the future to take place in your country. But this is the kind of law that's still alive in the United States. So I am so excited to be here and to get this magnificent lei, which I will take back and show to everybody in Hawaii. Maybe we will have something like it. But I'm grateful for the chance to address all of you and encourage you to be freedom fighters in the tradition of Justice Ravindran, in the tradition of Ashoka, in the tradition of Mahatma Gandhi, and in the tradition of your dean, who is extraordinary. I have two deans here that are extraordinary. I am lucky enough to be an adjunct faculty member with the great Dean Raj Kumar. But also my other dean is here, who is, thank you, our dean from the University of Hawaii, who is kind of our avatar of justice as well, who you'll get a chance to hear from. So congratulations, you've got the freedom fighters around you, and I know you've got the heart for it. Congratulations for being the first batch, all of you that are the first batch. I look forward to hearing about your accomplishments in the future. Aloha.
Thank you very much, Justice Wilson. I call upon Justice Sabrina McKenna.
Aloha. I'm Sabrina McKenna, also of the Supreme Court of Hawaii. First of all, I just want to provide a little bit of framework. We have federal and state judges here. You're probably aware of our federal constitution, but I want to make sure that you're aware that each state also, in each of our 50 states also has its own constitutions. And state high court, the highest apex courts of each state, are free to interpret their own constitutions to provide greater rights than are provided under the federal constitution. The states that are represented here, we do that robustly. And that is why we have some opinions. For example, the opinion written by Justice Edens, in which Justice Wilson and I joined, which recognizes a Hawaii constitutional right, not just to a clean and healthful environment, but also to a life-sustaining climate. And it's the first court in the country to so hold. But in any event, so we do provide judicial review, not just of the federal constitution, but also of state constitutions. And I want you to be aware, for those of you who study U.S. constitutional law, have any of you heard of a case called Marbury versus Madison? Okay, I see a lot of people nodding their heads. It is an 1803 opinion of the United States Supreme Court in which most people, most legal scholars say this is where judicial review started, with the third branch of government, the judicial branch, Marbury versus Madison. I want to debunk that notion. As I mentioned, all states had their own constitutions, and those came before the federal constitution. The Bill of Rights that was passed in 1791, first 10 amendments to the United States Constitution, were based on provisions already existing in state constitutions. And state Supreme Courts were already conducting judicial review from the late 1770s. Therefore, judicial review was a concept that was well developed in the United States through state Supreme Court decisions before Marbury versus Madison. So I just want to leave you with that knowledge. So I want to focus on the question that was asked as to the future of judicial review. And I want to focus on the issue of who is going to conduct the judicial review. Obviously, it's usually the apex courts, right, who have the binding power to make binding decisions to all of the lower courts. So who is going to be the people, the judiciary that conducts that judicial review? I want to focus on the issue of the rule of law, which is one of the topics here, please look up an organization called the World Justice Project, international leaders throughout the world. They outline 4 principles of the rule of law. The first principle is accountability. Private and public actors are accountable under the law. The second principle is just laws. The laws must be just, fair, and that includes access to justice. The third principle is open government. The government must be open and transparent. But I want to focus on the fourth principle, accessible and impartial dispute resolution. This fourth principle of the rule of law says that justice must be performed through neutrals, judges, who are competent, ethical, and as an aside, we're having an issue with ethics at the United States Supreme Court right now. Ethical, have adequate resources, and represent the communities they serve. Represent the communities they serve. So I leave you with a thought that the principle of the rule of law is that the judiciary must represent the communities they serve. The United States is not in full compliance with that. A majority of the judges, great majority of the judges in the United States are white men. 24 states don't have any black state Supreme Court justices. But we have about 38% women members of the bar now, lawyers, and about the same percentage nationwide of judges, right? We're very proud in Hawaii that we have the most diverse judiciary in the United States. We keep statistics. We know what people's gender. We don't follow religious background, I don't think, but LGBTQ status, we follow, we know that, and I will point out that I am the first Asian open member of the queer community who's Asian American to serve on the state court of last resort. So, we have that, but, so your judiciary, the comment that I would like to make, it's wonderful, wonderful, very strong, but I think that it's important for different voices to be heard. Different voices make a difference in judicial opinions. I can tell you that from personal experience. Presence of women, other minorities, different backgrounds makes a difference. Oliver Wendell Holmes Jr., one of the greatest justices of the United States Supreme Court, said that the life of the law has not been logic, it has been experience. Experience shapes the law. So you need different points of view. In India, your high courts and your Supreme Court, women and other minorities are grossly underrepresented. So I submit to you that your judiciary is not in compliance with the rule of law. And I know that's a strong statement, but if you follow the logic, it's there. And if you follow the experience, I think that's true too. So that is the thought that I wanted to leave you with. And in terms of judicial review, it's not just the judges that perform it. You, law schools, lawyers, law professors, you perform a very, very important role in holding truth to power and commenting and writing law review articles and criticizing appropriately the decisions of our high courts. Thank you very much.
We have to call upon Justice and I.
Good morning and welcome, and I'm going to try this again. It fell flat yesterday. Just do it. I can't say aloha, I can't say mahalo, I'm not from Hawaii. So just do it. Does anybody know what that means? Raise your hand if you know what that means.
Or you've heard it before.
Or you've heard it
Just
before.
do it.
Just do it. Nike. Okay, I'm from Oregon. That's the home of Nike. Phil Knight. Innovation. Read his book, Shoe Dog. It's a kid, a 7th grader who didn't make the baseball team, and basically said, I'm going to get the really smart kids and we're going to go out and work everybody. And innovation, inventiveness, and a deep commitment to the human body and the human spirit, and understanding that the world was for people who were going to do risk and high reward. So I'm from Oregon, and I'm really proud of the fact that I grew up in that tradition, and I don't run. It's not who I am, but all my kids run, and I've been involved a long time, and I was there last night, Steve Prefontaine ran. So there's a guy who took on the establishment, and in so many ways he's outlived everybody, because how we treated people, speaking truth to power in athletics, he spoke truth to athletics. It's very difficult to do that. That's a very powerful organization in our country. Okay, I digress on that, but I want to say, I wish your Justice of your Supreme Court there would maybe come and lecture some of ours. It would be really lovely to have his words of wisdom shared with people in our judiciary. What a magnificent talk today. Thank you. I wrote the same thing, rights and powers. The overuse of power, the accumulation of power, the accumulation of money and greed, the division of haves and have-nots is destroying this world. Absolutely destroying this world, and it's happening in our country. And it's been so important and powerful for us to see and hear what you're all doing about it. It is beyond inspirational, and I will always remember every Friday where I was today. And it'll just be a remembrance of what this campus is all about. And what I have to say honestly is each one of you, I bow down, a human rights lawyer. I bow down to what you've done as you're writing on the hearts of the next generation. It's the investment in people that you're accomplishing that's going to save us. The rule of law is important, and it's a structure, but it is no good if we don't have the people who have the energy, intellect, breadth of knowledge to be able to come in and challenge us day in and day out, and use the tools of the rule of law, use the Constitution, and frame it for how we can deal with complex rights and responsibilities as we move forward, so the haves and the have-nots are not further and further apart. And that destabilization in democracy is why we're having trouble in our country. We're destabilized. And the difficulty is we've not invested in education. And it brings tears to my eyes, honestly, to sit here and out of joy to see what your country is doing, what the leadership is doing, what my now new hero is Professor Kumar, who is, what he said, sharing resources. We're still competing between higher education institutions and selfish. Selfishness is ruining us. Selfishness is putting things forward. And how does that get broken? People like all of you, you're young lawyers, have the courage to come into court and stand up for people. Have us have to answer tough questions. What's the power and the responsibilities? I have to tell you, and it's just so inspiring to be here, Candace, tell you. I want you to know that one of the things, as I was listening to people talk, I read a book, listened to a book a while ago called My Life on the Road. Does anybody know who Gloria Steinem is? All right, Gloria Steinem is an amazing woman, and you know what she really was inspired? Riding the trains of India. It's a phenomenal read, and she rode with all the women. She rode in cars after cars after cars, talking and what are the problems in India? What are the problems she should work on? She talked about circles. She came back and started the entire women's movement out of India. So you have a research dean here whose body of research is on rape. And I bow down to the work that you're doing, because what's happening in our country is we've taken a right away from women. A right has been taken away. Choices been taken away. Women's bodies taken away. When rape happens, there are going to be state laws that will not allow the woman to make a choice about whether to carry that baby to term. And so what we will continue to do in our country is bring in more unwanted children. And we're not taking care of the ones we have now. So I want you to know, again, you're all young, you're the first class. You're going to be forever celebrated as the first class going through this amazing story. you have a human rights leader, you have a woman who's got an area of expertise in rape law. I brought this pamphlet, you know, my day job is repairing damaged adults and resolving civil cases. Criminal law is working with people who are going to be sentenced and then coming back out. Civil law is we're managing these cases, and a lot of times we have to manage the lawyers, sorry about that, but we have to manage the lawyers who don't necessarily know how to get their cases moving forward, and so we can manage and get our cases resolved and work with the lawyers. But my free time for more than 30 years has been to donate time to be on the board of the University Early Intervention Program for Children of Abuse and Neglect with therapeutic preschools, using the law, brain, and behavior research out of Harvard, and doing better and understanding that I have to leave the generation something more important, and what we have to do is right on the hearts of children. So the best thing we can do is build an infrastructure to care for our children. Because at the bottom line, as we bring people into the rule of law, they have to be healthy. They have to have an education. They have to understand what the rules are. They have to have an opportunity to come in and have the kind of life many of us have had. And those who've overcome really difficult lives and have the amazing resilience are extraordinary people, and I revere those folks, and those are who I look for. But so many people are not resilient and don't have a chance. So as I looked around our country and what we're doing, and sort of we're going backwards, forwards on these issues, what I'd love to partner with your university in terms of, and I'll have it for you, is building something that's a therapeutic program that uses the research to do something different, to get people ready to be able to use the rule of law. And so I'm all over the map on this because there's so many things to talk about in a different way. But I've worked in all three branches of government. So I know how to use the legislative branch, and you're going to hear from Judge Tukey, who I revere because he worked in legislative council. He worked on how to draft legislation. Now, if you know how to draft legislation and work with an elected body like that, and then you know that it's going to come to the courts, I mean, there's a way of understanding how all three branches,
wind up in a few
okay,
minutes.
wrap up. All three branches of government work together. So what I would like to say to you is, get as many experiences as you can in law school. Learn about how all those branches work. Find the people who are your mentors, and understand that we have our obligation to train you as the next legal leaders and right on your hearts. And it is just an incredible privilege to see the magnificence of this building, the magnificence of the students and the collective faculty that you have. Take advantage of it because you will lead us. So thank you.
I'll call upon Justice George Bennett.
Hello, everybody. I'm Justice Todd Edens, Hawaii Supreme Court. When you look at the rule of law and you look at judicial review, those are common features of both of our democracies. In the constitutional democracy, judicial review is to assess the constitutionality or the legality of laws passed by the legislative and the executive branch. And that is a vital, critical component to constitutional democracies. But what happens when the judicial branch lacks confidence? The rule of law erodes, and that's what's happening in our country. A handful of justices have now erased the constitutional right, and that's what the Roe versus Wade decision. But not only that, the very next day, they allowed guns under the Second Amendment to be toted around in public. We now have a situation in Hawaii where people can walk around with firearms on the public beaches, on Waikiki Beach. It's absolutely outrageous. And what's happening now is the public is losing confidence in the judiciary. And when the public loses confidence in the judiciary, the rule of law erodes. And that's what needs to be protected. And when I look around and see so many bright students, you have a remarkable opportunity here. It's the first batch of students at this school. You have a very unique opportunity to shape the way your people in this country live and to shape the way the law is. And it's a very exciting thing. Now, I look back at our law school, and you'll hear from our fine dean, but our law school at the University of Hawaii, both Justice McKenna and I are graduates of law school. We're the only two Hawaii Supreme Court justices who ever graduated from that law school. That law school started 50 years ago. And that first batch of law students at that school, many of them, one became a governor of the state of Hawaii. They were leaders in our community, and you have the opportunity to do that. And I invite you to use the legal skills that you learned from this institution to serve the public. Now, there's a tendency for some people to come to law school because it's just a means to something, a means to financial success, a means to your own self-interest. I invite you to have a public-spirited interest to serve your communities. You probably come from all over this great country. Take back what you learned to your communities to serve your public. When I listened to your eminent justice speak, he talked about one thing that resonated with me, and it was the public defender aspect, where if you don't have money and you're charged with a crime, in America, you are entitled to legal representation. I started my career as a public defender, representing people who could not afford legal representation, and using my skills to help them. And that sort of fostered a spirit in me that all of us have. Now look, all of us could probably go out in the private sector, and we were in the private sector, many of us, and made a lot of money. That's not where it's at. Where it's at is serving your communities, using your skills to advance the rule of law, to advance human dignity. In our country, many young lawyers like you are now coming out, seeing what our United States Supreme Court has done, and going into their communities and advocating. As Justice McKenna mentioned, we have a state and a federal system. The federal Supreme Court has erased the constitutional right. It's essentially allowed state-sanctioned forced birth. But what's happening in many states is people are rebelling about that. And there's constitutional amendments in those states to allow human dignity, to allow reproductive liberty. And a lot of that movement's coming from young people, from young lawyers who are using and advancing the rule of law from the things that they know to propel human dignity, to propel liberty. And if I leave you with one thing as you progress in your legal careers and you progress in law school, think about people who are not here, people who don't have your opportunity, and think of how they need you to help them. Thank you very much.
I'd like to ask Justice Sarah Ellis.
Thank you, and good morning, and I'm just going to speak from here as opposed to using up the time for the walk. So, Justice Ravindran, you know, one of the things that you mentioned is that frequent changes in the law is not good for the country, right, when we're talking about judicial review. And what that translates to in the United States anyway is the idea of stare decisis, where certain things have been decided, it's precedent, and you can rely on those things, and that creates predictability and an understanding of the law. However, there's then this tension between stare decisis and how does the law develop as society changes and evolves. And so when you look at the future of judicial review, you have to address that tension. And you cannot freeze the law in time or space because our society is changing. But you can't throw out in one fell swoop what people have come to rely upon and understand what the law is. So one of the things in terms of the future of judicial review is that judges have a responsibility when they are writing opinions and drafting judgments to be very clear and transparent about their reasonings. and explain in language that is accessible to all, how did you get to that decision? So that anyone who picks it up can read and understand how the law evolves and develops, and that creates confidence in the law. The other thing is that we need to focus on civil education, on civics education, I'm sorry. That the person walking on the street understands the role of the different branches of government, understands what the executive branch does, what the legislative branch does, what the judicial branch does, and that judges are supposed to be neutral and apolitical. Their decisions come from the application of the law to the facts. Nothing more, nothing less. And when they do that, then the average citizen or the lawyers in bar associations will be able to speak up for judges when the other branches attempt to intervene. In the United States, judges we can't advocate for ourselves. When someone says something, we cannot speak. And we rely on the bar associations to stand up for us and to speak for us, to write opinion pieces in the Wall Street Journal saying that, you know, this is not appropriate or that is not appropriate. And the last thing that I think we need to do as judges, and this last pillar, when we worry about how other branches may impede on the work of judicial review, is that we keep our own house clean. And what I mean by that is that judges do what is appropriate, that you stay within your lane, that you act with judicial restraint in writing these clear opinions, in behaving in ways that avoid any appearance of politicization or polarization, that we act with ethics and a code of conduct, so that nobody believes that we could possibly be corrupt. In the United States, and I'll end with this, is that Congress, I'm a federal judge, and Congress is attempting to have an inspector general over the judiciary. And judges need to fight back against that, because that is a way that erodes judicial review, that says that judges can't manage themselves. And as we are, we govern ourselves, judges do. We have a series, it's called the Judicial Conference. And there are various committees, and judges sit on those committees. So I sit on one of those. And as judges, we must behave with the highest level of ethics to instill confidence, not just in society, but in the other branches of government, so that they know that we are behaving in a way that we can take care of ourselves, and they are not to encroach on what we do, that they are not to install an inspector general, that we will do what we need to do. And I think as we move into the future, that judicial review is something that is so valuable and precious that we must do everything we can to protect it and show that we are neutral and can be relied upon in the decisions that we make. So I thank you for those questions.
Yeah, I'd like to thank all our panelists for their participation. We have a few minutes more, and I'd like to open up the floor to the audience for questions. Any questions?
Press the mic and then speak there. Yeah. Press the button.
Good morning, graduate judges. Thanks to the university for invitation also.
I come from the institution, that National Institute of Mental Health and Neurosciences. Just you have said that in child and adolescent psychiatry we are working. So on those lines we are working. So there are a lot of issues like child sexual abuses, those kind of issues also comes to us while dealing in the public health, assessing, doing diagnosis, and doing social welfare benefit to them. Those kind of issues are there. How we can collaborate, because the government of India has already given Sambada project. There is one project by Women and Child Development Ministry which is centered to it.
Can you please be brief?
Yes.
We just have a few minutes left.
So there is a need to have collaboration between the countries and various institutions across country also, what I feel. In that, how we can improve it. Suggestion.
Does anybody have a response?
You know, we're not very good at it. We think we're fairly arrogant as a country, and I hate to say that, but that's the truth. But we have much to learn, and you're coming into our country and coming in droves and helping us sort of raise our game. But we cannot survive if we do not start sharing resources and taking some of these issues on internationally and globally. The products that go around the world have to be sustainable products. We have to figure out the best technology so that we can provide the most without using the resources. That requires companies in our country that's going one direction and others to start collaborating. We're just taking all the resources right now in this world, and we're not stewards of the next generation and generations to come. It's the courage. The gentleman who spoke up here, to be inspired by individuals who have that shared vision, have incredible talents, strong egos, but understand that we are better together, and the world requires us to share as opposed to compete, ruthlessly compete. So I think companies are starting to figure out that that's what the public wants. So back to the three branches of government, I believe that the three branches of government have really important roles, and the role of the public is to demand, the students to demand that we do this better and that people work together for better solutions. So it's really all about the individual and leadership, and we've seen it here today, what's possible when you have that kind of leadership and courage. Is that somewhat helpful? I wish there were ways we could form to see it, but when we see it, it's unbelievable.
Yeah, we'll just have one more question because we're going to wind up.
Thank you so much. Very, very short question. I was, I think we live in a world where it's either or, either, unfortunately over 20 years ago, propounded either with us or against us, right? And I think you addressed the question of restraint from the bench. And I was reminded of something that happened many years ago where one of our prime ministers angrily called a retired judge who was leading a commission as stupid, and then immediately made an apology thereafter. Restraint is a two-way street, isn't it? How do you see in your country the fact that we've got a political discourse here, perhaps, and even over there, that's increasingly this either or. You're either for us. Criticism is lost in personal attacks. Any thoughts on that? Restraint on all sides. Thank you.
Yes, I do. I think that in terms of restraint, that it does go back to civics, right? And how we treat one another. And that as judges, we are to be restrained in our opinions and understand the law and have a respect for the law, have a respect for precedent. And in our politicians, that they also should be restrained, and that they should understand that they are there to govern and lead. And when we do talk about rights versus power, that yes, they have great power, as do judges, but that we are all called to public service. And we need to remember that, and if we keep that front and center, that we are there to serve, then I think the restraint comes naturally in the restraint.
One sentence. Compromise is not a bad thing.
We're watching with great interest in what's happening in our country right now, whether the courts will sustain in many decisions, and are we the rule of law? but most importantly, it goes back to education generally. When people don't understand how things work, when people don't understand and think everybody has something, they're desperate and they're in despair. Drugs, alcohol, guns, violence, get what you want, take what you want, treat people the way you think you're being treated. We have to do a better job, and that's why I'm going overboard. The investment that you're making in education and your future is going to rebound in so many different ways and solve the problems you're talking about, and I hope we can keep up.
But India is a great teacher on this. Maybe things have gotten polarized in a way that is unfortunate at the moment, but in the future, I mean, the fact that diversity has allowed this country to still hang together through a kind of mutual respect, idea of human dignity and respecting differences. In some ways, I think India, again, is starting to lead that for the world. So I would hope that India can be able to draw within the community, not necessarily the community of politicians, for the kind of culture that has allowed it to be a place, a sacred country with a sense of faith. So I think we kind of look to leadership from you so that it's not just, you know, a conflict, right or wrong situation.
Do you want to speak?
One piece of information for Justice McKenna.
Yes.
You felt that in India women are underrepresented in the judiciary. Let me share a happy thought. Except high courts and supreme courts, where the recruitment is not done in an organized manner, but on a personal level, in all courts, that is the district judiciary and trial judiciary, at present, the women who are passing out and becoming judges are more than the men. And within about 5 to 10 years, there will be percolation up, not percolation down, because when they get promoted, they will be the
What
high court.
percentage of your high court judges are from the sessions courts?
No, it is 1/3.
One third now.
One-
Good,
One-third.
wonderful.
And the representation will go up, and we expect within a decade, women will be holding 50% of posts.
I look forward to that day.
Yeah.
Thank
I
you.
just want to-
All our panelists for their valuable insights, and we will now break for coffee. Thank you.
We'll proceed towards our thematic session 2, Law in the Globalizing World, Challenges for the Rule of Law and Access to Justice. Let me invite our distinguished panelist, Honorable Judge Jenny Rivera, Associate Judge, New York State Court of Appeals, Honorable Judge Josephine Staton, Judge, U.S. District Court of California, Honorable Judge Douglas Tukey, Judge, Oregon Court of Appeals, Honorable Mr. Justice Andre, Junior Judge, U.S. District Court, Central District of California, Professor Kamali Nelson, Dean William School of Law, University of Hawaii, our founding Vice Chancellor, Professor Y.S.R. Modi, who will moderate the session.
We'll start shortly the moment the other panelists join back. We've decided to skip the tea break. The moment the other panelists come, we'll start.
Just means I get 20 minutes to talk.
Absolutely.
Ladies and gentlemen, I welcome you back to the second thematic session on law in a globalizing world, challenges for the rule of law and access to justice. I wish to extend a warm welcome to all the distinguished panelists. Well, speaking of challenges, there are many. In fact, a few days back in our country, there was a raid on a media organization called Newsclick. Several journalists have been arrested, and they have not been told of the charges underlying the arrest, and with the result that there's no way they could defend themselves. So there's a serious challenge to the rule of law and all the established or accepted universal standards. A few years back, there was a Jesuit priest called Father Stan Swami who was arrested under the charge of waging a war against the state on some trumped up evidence, and then he was denied many basic things in the prison while under judicial custody, including access to a zipper. He was a paralytic stroke patient, and he wanted books, and he was denied the basic health care, with the result that he eventually died. It's called, it can be termed as a death by negligence and while in judicial custody. And right now there's another professor, Sai Baba, who's held in prison. He's a paraplegic, again with 90% movement lost, below his lower chest, and yet again he's being denied the right to health care. There are so many other challenges, even the the progress of new technologies, including artificial intelligence, and there are challenges related to international terrorism, transnational crimes, including cyber crime, cyber security, and also challenges emanating from the climate change and sustainable development. Justice McKenna referred in her address about the need to hear the voices of women and minorities, and Justice Ravindran also in his inaugural address mentioned about this aspect. I want to raise a few questions, what measures can we take to ensure that marginalized and vulnerable communities have equal access to justice in a globalizing world? And I'll start with, please start.
All right, so I'm going to step up here. So I'm not sure if we're answering one particular question, but I'm going to take that question about how marginalized communities and access to justice. First of all, let me say thank you for having me here. It's just wonderful to see faces of fresh law students. My understanding is that you started sometime perhaps in September. This is your first year of law school, and before I get to the specific issue, I want to go back to something that Professor Raj Kumar said when he stood up here, and that is, it takes eternal vigilance to protect democracy. Now, when I was going through law school in the last century, unfortunately, I don't think I would have thought that that had any personal meaning to me at all in the United States. Protect democracy, yeah, we have democracy. What is there to protect? It's just there. What I didn't realize was the fragility of democracy. Now, why am I going back to democracy when I was just asked a question about how do we give access to justice to marginalized communities? Because the answer is democracy. And I think that while we can talk around the edges about things that courts can do to advance rights of marginalized communities, the best thing that courts can do to advance those interests is to protect the very structure of democracy. I like to think that there are three major threats to democracy. Well, I don't like to think that, there just are. And I wish there were no threats to democracy. But they are autocracy, populism, and I think judicial imperialism as well. And we heard about that when we heard about judicial restraint. So how do we protect from autocracy? Because we're not going to globalize if we don't have democracies. Autocracy, of course, is where we lose separation of powers, where the courts are mere tools of the political leaders for consolidation of power and for social control. And so we have to be vigilant against that. But there was a study by two political science professors. They examined 163 different countries in troubled times, right? Times where there were economic threats, where there were threats from other countries, terrorist threats, and found that those democracies that remained strong in those troubled times were those that had an independent judiciary. That's what we're talking about here. And how do we do that? We've alluded to that earlier. I think one way is that we maintain a very strong perception in the public of an independent judiciary and the reality of one. So there are two public ways that we can do that. We can, first of all, make sure that we are not corrupt and there's no perception of corruption by following codes of conduct, strict codes of conduct, and financial disclosure, so that nobody thinks we are beholden to those who are in front of us, or that we are not impartial. The second is that we follow the rule of law. Right? And so we heard that the Justice Ravindran said, widely discretionary authority or arbitrary exercise of power, that's where you lose the rule of law. So that goes into judicial restraint, which goes into the issue of judicial imperialism. I'm not going to go through all of these because I want to give my colleagues time and I want to hear questions, but those are the three threats that I see. I think the courts can best serve marginalized communities by maintaining democracy so that they can have a voice. Democracy is the voice of the marginalized.
Thank you. May I now request Professor Nelson, Dean, School of Law, University of Hawaii, to give her views.
Timer on. All right. Good morning, everyone. Good morning. Students, can you raise your hands? Okay, what kind of music do you listen to? What kind of music do you listen to?
Music.
R&B. What do you listen to? Kind of music? What, okay, what else? Anyone, tell me more. What's popular music that you listen to?
50 Cent.
Rap? Okay.
50 Cent.
50 Cent. Okay, excellent. Let me riff on that. So I was born in, and you were going to say something, right? Taylor Swift. Okay, you're a Swiftie. You're a Swiftie. Excellent. Okay, so music resonates, and I'm going to do something a little different because I think one of the challenges that we have to face is how to get the message out beyond ourselves, right? We're in this very privileged space as students of the law, but I think one of the ways that we can deal with the threats to globalization, the threats to autocracy, is to meet people where they are. So Chuck D, a famous rapper of the group Public Enemy, some of you might understand, said back in the 80s, hip-hop and rap is CNN to black people in America. I was born in Jamaica. Dance hall and reggae is the equivalent in Jamaica. Just like yoga in India, reggae in Jamaica was given UNESCO status. It was given the same-sex status because UNESCO obviously preserves cultural, iconic frames that give voice to the oppressed, for example, and they said that reggae functions as a vehicle of social commentary to provide a voice to all. So one of the threats, I think, to globalization is the refusal to understand that the next generation of globalization is that we are one, citing to Bob Marley, one love, one heart. Let's get together, right? So when we think about these impetuses, I want to suggest to you that we need to think about how to spread the message of the rule of law, not just in the courtrooms and the classrooms. You're smart enough to know how to use media, and I want to commend the good dean and the chancellor of this university for also starting a school of creative media, right? And you said arts. How does justice intersect with arts? How does justice intersect with the arts, rather, and with media, creative media, to get the message out? Surely we can't just talk amongst ourselves. To truly democratize the message, we have to meet people where they are. So I want to suggest to you, in the remaining minute that I have, that we have to think more capaciously. Martin Luther King, who obviously stood at the foot of Gandhi, said, if we are to have peace on earth, our loyalties must become ecumenical rather than sectional. Our loyalties must transcend our race, our tribe, our class, and our nation. And this means we must develop a world perspective. And I want to urge us to think in this year of the 50th anniversary of hip-hop, creatively as lawyers, how to get that message out beyond the courtrooms, beyond the classrooms, beyond the traditional ways of looking at the law, because we have failed in so many respects and the trust has been broken. And it's been broken for good reason in many instances. So I urge us, as we think about globalization moving beyond the traditional frame into the one love frame, to hearken to this message. People think about the message of one love, one heart as a good vibe. It's not just a dance song. Part of what Bob Marley said, if you look at the lyrics, hear the children crying, one love. Let's get together and fight this holy Armageddon. Have pity on those whose chances grow slimmer. Let's get together. I'm pleading for mankind. I would say I'm pleading for humankind. So in sum, my message is that in coming together and embracing in one love and one heart, we have to move beyond, push the law out to where people live. And I think you as lawyers and leaders and students know better than we do where that heartbeat and pulse is. And so I urge you to think creatively, interdisciplinarily, internationally about how to do that. Because the law has to live beyond the hallowed halls and the edifices of our legal structures. And I'll stop there.
Yeah. May I request Honorable Justice Andre Biroti to give his views.
All right, if it's okay, I'll just speak from here. Greetings, everyone, and heartfelt congratulations to all of you as the inaugural class of this law school. Whether you like it or not, you are setting history, and you will always be a part of the history of this law school, and I hope you are able to enjoy and embrace the moment right now, but throughout the course of your tenure in law school. Law school can go up and down, but it is an opportunity to use skill sets that others don't have, and that relates to the question of how you deal with the marginalized communities. I think lawyers have a responsibility. During the course of our trip here, I had the opportunity to hear from Justice Kumar, retired Justice Kumar from the Supreme Court, and he said so succinctly and so aptly that lawyers are the stewards of the rule of law. And that's what you all are going to aspire and eventually become, pushing the judges to raise these issues. It was interesting to hear him and Justice Rendran talk about how in India, someone just writing a letter to the court can be the initiation of a legal proceeding. That's powerful, and that is a demonstration of this country's receptiveness to ensuring that everyone has access to justice. And that's something that, again, what I find interesting is that judges get asked the question of how do we ensure it? But in many ways, we are more reactive to it. The cases, we don't wake up in the morning and just write opinions just because we feel like it. I think some of us wish we could, but it's always in response to litigation and issue. And who raises those? Whether it's someone in the mountains that raises an issue or people like you. That's where it comes from, and that's where the import of you as lawyers being stewards for the rule of law and access to justice. Now, there are other things that I think we need to also think about as it relates to that and ensuring marginalized communities get access to justice. In the United States, one form of that is pro bono representation. Law firms, many law firms have now institutionalized and made part of their foundation that if you work at this firm, you have X amount of hours that you need to bill for the firm, obviously for business, but you're also required to bill a certain amount for pro bono cases for free for people who are marginalized. I understand that that's somewhat of a newer concept here in this country, but you, as the youth, as Dean Nelson said, are going to be the driving force of that. And so think about that as you go work at firms and throw out those ideas so that you can hopefully cause them to start the process of beginning that and making that part of the fabric of those firms. Because again, that gets to access to justice. Another thing I think is also important is transparency in what we do and say as judges. And that includes opening up the doors to the courtroom. I found it fascinating during our time here, we got to see the high court in action. But I was curious as to how often does the public get to see that? Are those hearings videotaped? You know, there's been a lot of debate and discussion in the federal courts about videoing hearings. One of the silver linings of COVID was the fact that it caused federal courts to do just that. And in our courtroom, in my courtroom I should say, I still have my Zoom link up. You can go on the website, and if there's a hearing, you just click on the Zoom link, and you can watch. And I think that's important to give the community the sense that, hey, I can watch this and see what is going on in our respective courts, particularly when you have huge jurisdictions. Our district has, I think, about 19 million people. Some people have to drive hours away to get to court. The video capabilities can help reduce the traffic and the burdens that it takes to bring litigants to court and give them an opportunity to still be heard. And so, like I said, I want to end with what I stated earlier. Lawyers are the stewards for justice and the rule of law. And as it relates to access to justice, I would also ask you to think about a quote that I heard many moons ago. This person said, public service is the rent that you pay for your space on this earth. And so my hope for each and every one of you, no matter what you do, is to try to remember that as you're in law school, to pay that rent, help others, because you are in a situation where you have a higher education, you have a degree, you have skill sets that are going to put you in the position to help others. And I'll leave it at this. The former First Lady, Michelle Obama, said it so aptly. I just was sort of chills when I heard it. She said, each and every one of you, no matter what your background, no matter what your walk in life, each and every one of you have something great to contribute to this nation. You have that opportunity now. Use that to ensure the rule of law and access to justice. Thank you.
I now request Justice Jenny Rivera to give her remarks.
Thank you. Good morning. It is still morning. Very happy to be here. Thank you for the invitation. Thank you for inviting us to this space. I've been on the New York State Court of Appeals, which is our Supreme Court. It's the highest court in New York State. I've been on the court for 10.5 years, but before that, I spent most of my professional life walking halls like this, in these kinds of rooms, at the podium, working with students. I was a law professor for almost those 20 years. So I always feel very at home in an educational setting. So thank you for letting me be home for this short period of time, because we've been away for a few days, and it's been a wonderful trip. So I want to address your question regarding access to justice for marginalized communities, marginalized individuals in a globalizing environment, right? With the movement of globalization, which has now been moving on for, I would say, centuries. We think about it as more of a recent phenomenon, but what else but the United States reaching out to other parts of the world, to taking on colonies, is an effort at a version of globalization. That's a version of control. But I want to talk to you about procedural and substantive justice. We've talked a lot about justice. So these are ways that you can ensure access to justice when you're lawyers, as law students, and just as a member of your community. So procedural justice is perhaps the most obvious that people can think of in a legal setting. Particular rules of how you file documents, what those documents look like, what the time frames are, who can file them, who can't file them, where the lawyer stands, when the lawyer gets to speak, how the lawyer responds, etc. and so forth. You'll continue to learn about those things. And it's very important to learn that. I call that the rules of the game. If you don't know how procedure works, you will not be able to help your client. Right? Say in the law, if you don't have the law on your side, argue the facts. And if you don't have the facts, argue the law. But you've got to find the way to present that. And those are the rules of the game. You cannot help your client if you can never actually present anything to a judge. And in our system of justice, it is very easy for a lawyer to try and block their adversary from ever making an argument. You've got to be able to do that. So procedural justice, the ability to use the rules to ensure that people get what we call due process, the ability to communicate their argument, to be heard. And that's so critical for marginalized communities, individuals who are usually not heard or who are ignored when they speak out. And I'm very pleased to say that in our country, your country, people refuse to be ignored. They try to have us ignored, but we refuse to be ignored. We will keep speaking out. These are movements that respond to regression. So there's procedural justice, and then there's substantive justice. The merits of these cases, where you come out on these cases. And I will say that judges have a choice. You get a case, you see the case, you say, okay, the law has a little gray area over here, because we're on high courts. We get those kinds of cases. The cases where there are open questions, the cases where, frankly, you have a choice. You have a choice. You can either look at something and say the area is gray, and if I go in this direction, that means that a large swath of the community, or perhaps a small group in the community, will never have their rights fully exercised. If I go in this other direction, I open a door. I make it possible for people to live free. I make it possible for them to exercise the rights that I am able to exercise as a privileged member of a privileged profession. I have a choice. To me, that's substantive justice, when you have the choice. And you go in the direction that does not constrict rights, but expands rights. That to me is substantive justice. And something for you to think about. Because that's the way I would suggest that indeed communities that have otherwise been excluded or forced out have a way to find a path to have their voices heard and to change the law. And I know I only have a few seconds left. The former Justice is not here, but I do want to say publicly that I was very inspired by his comments. And I too wish that more of our judges would speak in this way, would speak about communities that are oppressed, would be used, I think the word greed, I've heard this now twice, yesterday and today. It's a word I feel very comfortable talking about because I think greed drives too much of human behavior, and judges should speak to this very negative side of human behavior and how it corrupts society. So I was very pleased to hear him speak about that. So thank you for the invitation. Please keep both these ideas in your mind. Think about how you can realize them and actualize on them. Procedural justice and substantive justice. Thank you.
Thank you. Let's do a few pictures.
So law in a globalizing world, I want to focus on international institutions and to get you to think about those, maybe working in them, how you can be a part of them, and or if you're not working in them, how you can harness the resources they have to better do what you're doing. I worked at the OSCE, which, like the UN, is it's an international, it's a political organization. I worked in Uzbekistan, and as an American was sent there to work in the office. I was responsible for the economic and environment dimension. But one of the things we did, we were resources. We worked with the people there. One of the things we did, we worked with the Women's Committee of Uzbekistan. We did small and medium business development trainings throughout the country, including Karshi and Termez. Termez is a province on the border of Afghanistan. We were also in Karakoram, Pakistan, which is where the Aral Sea is. Yes. But it's amazing because the ideas some of the women had, small textile business, small sweets, candy business, and we were able to facilitate that. but again, this was all people that came to us with these ideas. Another one, we worked with the National Youth Organization to train youth entrepreneurs, and the goal was to get together a business plan. And if we went through a training with local business leaders, and at the end, if they had done well, we with banks partnered to arrange. Basically, it was a microcredit program. So these are amazing opportunities to work in, to be a part of, to think about either going overseas or to think about what is here and how you can be a part of that and use it to do better what you're doing. Another program, I don't know if the American Bar Association Rule of Law program is here, but I want to kind of focus again on how marginalized groups can benefit from these programs. The UN has it's an Economic Commission for Europe convention. It's called the Aarhus Convention on Access to Information, Public Participation, Environmental Decision Making, and Access to Justice. So Ukraine was considering joining the convention, but a group of parliamentarians, professors, judges came to us and said, look, help us do this. So we put together a working group, and basically what they did is they went through all the national legislation, because again, if you're going to join it, you don't just join it, you have to implement it. And so I can still see the document. It was a giant document, but they had gone through it. Because they did this work, the parliament then joined the convention, and I think they were the 55th, I can't remember, 56 members. So it was a really amazing group to be a part of. But again, it's be aware of these international institutions and how they can, like I said, help you do what you're doing. And I have, because on our little break, we talked about the Fulbright program, but I want to kind of make a plug for that. Lakshmi told me about her program. She studied at Emory University in Atlanta. It really is an amazing opportunity. I had 2 Fulbrights. I did an LLM in Singapore, but the best part of it was I worked with the 2 women who were kind of at the beginning of the development of environmental law in Southeast Asia, and because I was there, I was able to see that. And I think the other thing is kind of I think of it the student and the professor program. I'm not sure if that's the way to describe it, but I went to Kazakhstan and taught two law courses for a semester at the Almaty Law Academy. So I would encourage all the students to be thinking about how a Fulbright can complement what you're doing. And I was also encouraged the Vice Chancellor to think about maybe bringing some Americans here. It's a wonderful program. It's fully funded. There are so many opportunities, and you can either bring here people to teach, to do research. I had a research teaching grant, but it's a really good opportunity. So be aware of that, and you have a wonderful resource here, Lakshmi, and if I could ever help with that, I would be really happy to do that.
Thank you, Justice. A lot of interesting ideas were thrown around, like the democracy, procedural justice, pro bono lawyering, access to justice for marginalized community, and intersection between justice with music, media and creative arts, and many other transparency. So we now have about 20 minutes, for Q&A. You are free to pose questions. The floor is open for Q&A. Yes, please.
Hi, good morning. I'm Roshan from School of Law. I have a small question, or rather two questions.
Use a mic, or speak a bit louder.
Okay, I will.
Yeah, you have to press that. Okay. Just press it and then speak.
Alright, so I just have to give a small citation before I proceed with this question. We have a brilliant law and constitution scholar here in India called Gautam Bhatia. In his recent book, Unsealed Covers, he defines a concept called as judicial evasion, and he defines it as, by keeping a case pending and delaying adjudication, the court effectively decides it in favor of the parties, most often the party in a stronger position, that is the government, simply by allowing the status quo to continue. So keeping in mind the idea of judicial evasion, I have two questions over here. Does agency lie more with the judiciary or the state, in this case, bias can skew the separation of power, number one. And the second one is, how can the judiciary have a safety mechanism in the form of a mitigation policy to handle this kind of bias leading to judicial evasion? Thank you.
Just turn it off. Okay, is it on? You raised a very good question. As soon as you were asking it, when you said judicial evasion, I thought, you're going to talk about, you're going to ask about pending cases and the fact that in case anybody is, wants a little bit of elaboration, the idea is that if you, as a judicial officer, have a case in front of you that could affect some change, but it may be controversial, it may be something that on a personal policy preference basis a judge wouldn't want to do, then you can maintain the status quo, i.e. the power of the existing party by simply not deciding. Nothing changes unless you change it with your decision. So that, I don't know if that's judicial evasion or another form of judicial activism, really. Doesn't sound activist, does it? Because we always think of activism as reaching out, but I think of activism as using your own policy preferences to decide cases. And it's dangerous whether it's through judicial evasion, not deciding something that's in front of you.
There's evasion.
The powers that be don't want to hear what I have to say. Should we just continue on? All right. So either way, whether it's by reaching out and deciding things that are sort of beyond your lane, as one of my colleagues put it, or whether it's not deciding something that's in your lane, either one is unacceptable. How do you prevent that? Really, goes back to those procedural rules that Justice Rivera was discussing earlier. The importance of having procedural rules for the judiciary that does not allow for stalling of cases. And we do have those, we really do. So, at least in the United States. I'm not sure if that's true in India as well. We have backlogs, of course, but we have ways of requiring judges to timely decide cases. So,
and maybe this is more in the weeds, but in our court, and I think actually it's nationwide, in our court, there's a rule that if a judge has not issued an opinion within, I think it's 6 months, the litigants can file a document with the court indicating a decision has not been made. Now, one might say, a judge can say, so what? You did that. But that, that filing goes not only to the judge who's assigned to the case, but to the chief judge, and then it ultimately gets reported at a higher level so that the administrative office of courts in the country have an understanding of what cases have been languishing for more than a certain period of time. Now, having said that, judges can explain, here's the reasons why I haven't decided the case, but it's a mechanism to sort of keep everyone accountable by having that process.
Okay. There's a thing beyond the in-house shaming, public shaming. We had that in New York City. We had a federal judge who had a particular type of motion that was pending over a year. And it was in one of the major newspapers. The motion got decided 30 days later. So there is that kind of shaming. I want to raise a different, respond to you with a different kind of, I don't really want to call it delay tactic, but let's say with this procedural justice. And what I think is an intersection between procedural and substantive justice in my example here. We had a case on my court. They came up to us in a rather expedited fashion. It was an individual with mental challenges and behavioral challenges. This had been an individual who had been in foster homes and various institution settings. She was a young woman. And as a consequence, she needed a particular type of setting to address her needs. So the state was trying to respond to her needs But unfortunately, where she lived, they didn't have those kinds of services. Under the system as it exists, she then went to a hospital to be tested, to be evaluated, etc. and so forth. But because they couldn't find a place immediately, she was held in the hospital over and over, days. This is more than a month. These are days that everyone agreed, and the doctor, everyone informed of this, agreed that that setting was the wrong setting. Regardless of the setting that would have been ideal, this was the setting that everyone agreed she shouldn't be here. She needs to be discharged. But you cannot discharge someone to a non-existent place. Now, this went on and on and on. Lots of administrative problems trying to find a place. In any event, what would be the corresponding version of the public defender, we have lawyers who work on behalf of individuals with mental health issues. It's called mental hygiene legal services. They represented her, brought an action to our court. While the action was pending, and in our court, once we grant it, usually takes a year before the case ever gets heard. But we expedited it, so it wasn't a full year, but it was months. They finally found a place for her. So they found a place for her. So she was discharged. So there's a concept called mootness. First-year students may not understand this concept yet. Mootness means there's no longer a case before you because the matter has been resolved. But there are things called exceptions to the mootness doctrine. So in this case, she found a place, there shouldn't be a case. But the argument was, but look, this is going to continue to happen. She will not be alone. And in fact, if the place where she was eventually located and lived, for whatever reason, she can't stay there. She's going to end up right back at the hospital because you don't have a system in place to ensure she gets the right kind of services in the right venue. Okay. So my court, the majority said it's moot. And we don't think that fits the exception. I said, and I dissented, there's no way that this is moot because everyone agrees they do not have a system in place to find a home for someone with these challenges. And this may happen to her again. So I made an argument about mootness. What that allowed was, because the majority didn't go to the merits, I went to the merits. This is what I say was that intersection of procedural and substantive justice. To say how, in my view, under the law, you could not allow, as a judge, for this individual to be kept in a setting that everyone agrees is the wrong setting. Not just wrong sort of morally, you say, well, that's just not right. It's wrong because it meant that her condition deteriorated in that setting. So you made it harder, even harder than it already was, to find a place for her. So anyway, the first-year students, you're going to learn about those kinds of concepts. So when you go to argue, you have to be ready when something like this happens to your client. If you wish to continue to pursue this case, sometimes strategically you say, we're done, it's moot, we don't want you to decide the case, you may think the court rebelled against you. What can you say? And in my view, just my view, I think stories are powerful. When I read this story, I could not see myself saying, it's moot, move on. I could not, in good conscience, make that decision, come to that conclusion.
Any other questions?
Maybe I'll just turn it off. Please go on.
Hi, first of all, thank you so much for being here. It's been fantastic listening to you two speak. And Justice Jenny, I couldn't agree more with you about the importance of procedural justice. I run a corporate law firm, very different from most people in this room, but the importance of procedural justice for the first-year law students or people who've just graduated cannot be overstated. And that applies not just in litigation, but I can tell you that it applies in every facet of the practice of law. Now, one thing that I do want to discuss and really get this panel's opinion on is we're talking about access to justice, we're talking about how we can make this better for, democratize it and everything. And something that a lot of the students here probably relate to is social media and the impact of social media and the use of social media in everyday life. So is there, so I have two questions here. One is, of course, how can we use social media to make, to provide better access to justice to everybody, especially in a country like India where there are remote parts where people don't even understand the concept of courts, right? The most they would have probably heard about is a panchayat. And even that is really after levels and levels of, counseling and education and, have them come forward and, do this.
I'm
That's
sorry,
one.
what is the thing you just referred to?
That's a panchayat. A panchayat
Unit
is
of local self-government in the
it's
villages.
self-government, yeah, where the village head sort of usually is the sarpanch or the chief judge, so to say, and they have the village elders or the seniors who sit with them and try to provide justice to people who bring it before this forum, anytime they have an issue.
The original dispute resolution model.
Some sort of regional dispute, and just so to add some context, and I know I'm digressing a little bit here, but a few years ago, and I was a law student back then, we actually did this research about how a lot of the panchayat rajs in various states and various districts, there was a law that came about to bring women representation in there, right? So for, since we were talking about it, that's something that happened, I want to say back in 2006, 2007, this is before I moved to the US. So it was fantastic for me as a young law student to see that. But anyway, coming back to this, I don't want to take up too much time. I do want to understand, one, how do we, of course, use social media to bring better access to justice, especially for the youngsters who are in this room today. And then secondly, the one problem we've noticed with social media is the balance with judicial independence, judicial review. Because judges in India specifically, and I'm sure judges on this panel do exercise discretion once they take office with regard to interacting with the public, with regard to interacting with various peoples in different factions of life. So how do you, A, use social media to your advantage, and B, make sure that judicial independence is not compromised, but at the same time, provide access to justice to the larger one?
So maybe I'll try, can you hear me? To take a part of that anyway. Part of what I was trying to suggest is that there are multiple fora. So advocates will make their case in multiple fora. We are taught in schools of law about one very, very essential fora, right? The legal system. But I want to suggest that there are multiple fora that we should increasingly consider. I spoke about music meeting the masses, but I also think clearly media and social media is huge. And I think for you young people, you're born digital in a way that you are far more nimble with technology than we are. So to the extent there are social media influencers, conceptualize how, as an advocate for social justice and transformation and a corporate lawyer or whatever space you're in, you can similarly be an influencer. I think that's where the interdisciplinarity could come in. We have to be also more nimble with the use of technology, with the framing of communication strategy, with branding, and being savvy about how to get these messages about due process, knowing your rights, etc. out in multiple fora. And there are basic ways that we've seen this transformation, even through our various travels. When you go into a restroom in an airport, and you go into, for example, a women's stall, on the back, there are often articulations of rights for women. Are you being trafficked? Are you okay? If not, call this number. Is this happening to you? Is that happening to you? Just meeting people where they are. So if we can even start figuring things out like that and using social media more thoughtfully and intentionally, I think there's great possibility there. And I think the young people in this room might be far more savvy than those of us who are older in thinking about how we can amplify that. That's just one part of what I was trying to say. Thank you for asking that question.
Please, she wants to add.
I needed to add something that just an overarching issue that we haven't touched on. In our country, only 20% of the population can have access to a lawyer. There's a huge 80% of our country that cannot have access to a lawyer. The vision of this law school, which is a combination of human rights, cutting edge, bringing together multidisciplinary approaches, technology, theater, narratives, for all of that, there's a market over in our country about how to deliver better services. And if you want to work collaboratively, together what we have to do is provide access to justice and using that technology and framing all these principles together to use what you're driving, and that is
a world that will use technology to reach out into those small communities so that they have just as much access to justice as anyone else. There's a huge opportunity there, and I just need to tell you, it's one of the richest countries in the world, and we can only provide access to the very poor and to the very wealthy, and those in the middle are bankrupt if they actually have to use a lawyer. So there's your future for a market.
One of the things I'd add is I think courts have a responsibility to think about what their mission is and how they specifically can use the internet to give that. So I'm at the Oregon Court of Appeals, the Oregon Supreme Court. What we do is, we have our websites, all the decisions are there online for people to look at, the most recent decisions, the day they come out. The calendar is there. Now all the arguments are remote. So that never kind of happened before that way. And so that's us doing, I'm an appellate lawyer, and I think my decision should speak for itself. But also, I do think, so the court's letting people know this is what it's doing, and this is out there. I also think judges have different ideas about what they think their role is. One of the things that I think it's appropriate for judges to do is participate in a forum like this, or in some of the activities that we've been involved in. Law firms have organized events, and we've come and we've spoken about our views about all these topics. So I think there's also a responsibility on the bar to present opportunities for judges and courts to come and to speak about these events. So I have a flip phone, right? So you're about social media and all that, but I don't think it's appropriate for me to be posting comments about anything case on that. But I think the bar has a responsibility. And the other thing in terms of just access to justice, in Oregon, where Judge Aiken and I are from, the Oregon State Bar really tries to do a good job of providing access to information and access to justice. We have 2 programs through the statewide bar to give legal representation to people that otherwise wouldn't have it. There's a modest means program and a lawyer referral service. With the lawyer referral service, you can speak to a lawyer for about $30, and then after the 30 minutes, if you can talk about whether the representation would continue. But I think there's a lot of angles to your question.
Time for the viewer. Just very, very quickly. Social media is a way, of course, to communicate, which I think is great. But if all you do is communicate and don't activate, you're not helping. I think education is a beautiful thing, of course. I'm an educator. But social media really has to be movement media. If all you're going to do is with the thumbs, it's not going anywhere. You have to do more than that. So I really appreciate this question, because I think social media is terrific for people to talk about different things that concerns them, different issues that are resonant for their communities. But and I think it's a misnomer. Continuing to call it social media sounds like it's the big party line. And it has to be, that's good. Partying is nice. But at some point, if you're outraged, if you're concerned about your clients, if you want to see change, because we as judges cannot do these things, you have to use whatever you have available, whichever way you reach one another, wherever they are, for movement, right? So once you educate, say, now what are we going to do about it? Who's drafting the new legislation? What are we going to do to ensure that we want this person to become a judge? Because we know they're going to do the right thing when they sit on the bench. And so that movement meeting.
We'll take one last question from Professor Mallikarjuna. Okay. Professor Mallikarjuna, principal. Again.
Yes, I'm Mallikarjuna, principal of KLE Law College, Bengaluru. At the outset, congratulations to Dr. Raj and Dr. Saramurthy. And thank you both for bringing this great opportunity to Bangalore and having us here. Well, the question that bothers to me is, given the fluid nature of the concept of rule of law, rule of law has been considered as the friend and foe of administrative law. Similarly, when it comes to judicial review, while judges in UK go by stare decisis, and I believe judges in US go much by the philosophy of Justice Holmes about life of law. For me, if I read it correctly, Justice Holmes observes life of law is logic. Sorry, it's not logic, but it's logic tempered with experience. My only concern is we have done enough, be it the US Supreme Court, be it the Indian Supreme Court, in order to cater to the issues like concerns with law and morality, concerns with social morality, public morality versus constitutional morality, and sustainable development, etc. Courts have done enough good job. In the course of so doing, I am afraid whether the power that is exercised by the courts, is it turning out to be a judicial fiat, thus leading to, end of the day, law is nothing but last interpretation of the last judge of the apex court. Thus, would it really call for some restraints on judicial review is my fear. Kindly look forward.
Any questions?
Thank you.
Responses? Time we are past.
Very quick. I mean, that is exactly where I would have headed if I had spent more time on judicial imperialism. There's a Stanford professor, Mark Lemley, who talks about essentially the idea that neither side, conservative in our view, conservative or liberal, should want judicial imperialism. In other words, judges using their own policy preferences to decide cases. Sometimes, usually under the guise of some methodology to get there, but we all know where they're going, right? And neither side should want that, because just because you are in power at this point on the court, you may not be in 5 years. And if we continue to swing in one direction or another, just based on the composition of our Supreme Court, then we are going to lose all credibility with the public. We're going to lose the perception of an independent judiciary based in the rule of law. And when we lose that, we start losing our ability when necessary. There are times when we've had some decisions that have been groundbreaking and maybe have been perceived as somewhat stepping out of the lane, but I think the court had such credibility based on their staying in the lane that we could do that at times. Like our Brown versus Board of Education is one of those cases. I don't know if you're all familiar with that, but you have to maintain credibility. So that's a wonderful question. Thank you.
Quick comment from Dr. Raj.
Sorry, thank you so much. Fascinating panel. I just want to ask one question about the use of comparative law in decision making. In India, historically, Indian courts, not just the Supreme Court, but also high courts across the country, have never hesitated to use comparative law, cited references and cases from US, from the entire Commonwealth and the common law world, now even South Africa. And in the US, Justice Breyer would use occasionally comparative law. But I've been quite surprised by the fact that beyond the Supreme Court, the other courts in the US, the federal courts, the state Supreme Courts, but I even recommended to Justice Michael Wilson about referring to it. So my question to you is that, are there any limitations, statutory or institutional limitations that will pose difficulties for US judges in other courts to cite and draw upon jurisprudence developed by other courts around the world, beyond what Justice Scalia would call it, that we are the United States and we have to use, we really don't care what happens around the world, and we have to only interpret the US Constitution through US experience. And beyond that originalism point of view, is there anything else that prevents you from, referring to other judgments?
So let me try and tackle that. It's a very, very good question. Justice Sotomayor has also spoken, I think, quite eloquently on this. She says, I'll look for good ideas wherever they are to be found.
Yes.
Right? Which is that openness to the way others may have resolved issues, that there's some common aspect that we can all we can learn from. In any event, I think part of the resistance, I think it's a resistance, because if counsel presents you with a treaty that they think applies, you have to review it and think about whether or not it applies. But I think part of the resistance is, from the US perspective, seeing our form of government and judicial decision-making as exceptional. And there's a little bit of what you said with Scalia. Yes, it's about originalism in his view, but it's also about what is there to learn from someone else? How could there possibly be anything else to learn from someone else? We have this great democracy, we've got all the toys, we've got all the resources. What could there be to learn from someone else? I think there's a little bit of a strain in that, right? And to be fair, for those who see it that way, to the extent that the United States form of government has, from good intentions, sought to be a beacon light for others. Some of that light has dwindled in the last few years, obviously, but to be a beacon light for others. So there's a little bit of that. We think our system works so very well, what is there else to learn? So I think there's a little bit of that. But there is also, I think to our shame, the United States has failed to join certain treaties, right? I mean, they've just failed to accept them. And so if you're a judge, and the only mechanism by which our system says something does bind us is that we've recognized it either as a court or when it falls in this particular international political space that Congress has had to adopt it, you are then stuck. You are then stuck. You might be able to point out that there is this other way of thinking about this issue, or there are parts of the world where they found a path and sort of drop that in your writing, perhaps. But if you are unable to use it, because you're asking, are there limitations? That might be one of those categories where you're unable to use it. Obviously, even if it sounds like a very good way to address an issue, if it seems to be at odds with a basic constitutional principle, then again, you are stuck. All right, so if we say in our country, and I think this is a mistake that the Supreme Court has made quite some time ago, that we're going to measure some version of a constitutional violation based on intent. There has to be an intent. We say, well, we should be concerned with the outcomes, not why you did it, but the outcomes, right? That might be another word. But if there is some world consensus or some other path that other parts of the world have found where they are focusing not so much on intent but on the outcomes, we may say, well, that is unfortunately counter to a particular principle that the U.S. Supreme Court has identified as the guiding principle for the federal Constitution. As Justice McKenna mentioned before, we have our own state constitutions. We can say we're not bound by that analysis because you weren't analyzing our Constitution. We have a different way. That might open the door. So I hope that was not too sort of soft and trying to respond to
sorry for the see, we are already running into the last valedictory session, and in the interest, there's a question from a student, and in the interest of accommodating the student question, I have decided to do away with the key takeaways by the moderators. We'll straight take one last question and head into the
all of us got the takeaways.
Please go ahead. Students will have the priority.
What are the drawbacks of uniform civil code? If not any, why aren't we implementing it?
That's a question basically for Indian countries. That will require a separate one that we want. You want to respond to that?
No, I mean, I think, listen, I'm sure you know that, I'm sure you know that there was a clear intention on the part of the constitutional framers to move in the direction of having a uniform civil code. Much has happened in the last 75 years about the debate and discussion surrounding it. One of the things that has happened in every family law related to every religion is that a lot of progressive thinking has been infused into it that came from the respective social and progressives within those religions. But to have a uniform civil code does require some more consensus building efforts that has to happen across all religious persuasions. But I don't think we should resist the idea of a uniform civil code somehow, that it will undermine individual religious freedom, because if you remember when we moved from the original Hindu civil code to our own, the majority religion, which ended up having a lot of progressive reforms, there was a lot of resistance at that time as well, and many people were not ready to accept that. So this resistance will continue so long as we are able to take into cognizance the voices that come out of every religion and are providing equal ways to respond to those voices and come up with what should be a progressive approach towards having a legal framework for civil court matters.
I want to thank all the distinguished panelists for their views and perspectives. I hand it over to the Master of Ceremonies, Hemlata Sharma, to take it forward.
Thank you so much for enlightening us with such deep knowledge about the topic today. Let's proceed with the felicitation of our guests. So, can we have the Honorable Mr. Justice Michael Wilson, formal Judge, Supreme Court of Hawaii. We'll have Honorable Miss Justice Sabrina, Honorable Mr. Justice Todd, Honorable Judge N. Aiken, Honorable Judge Sarah Alice, Honorable Judge Jenny Rivera, Honorable Judge Josephine Staton, Honorable Judge Douglas Tukey, Honorable Judge Andre Viroche, Professor Camille Nancy, Professor Dr. C. Rajkumar, the founding Vice Chancellor of OP Jindal University, let me invite my colleague Ms. Arpita, Assistant Professor, School of Law, for vote of thanks.
Distinguished guests from the United States delegation, Vice Chancellor OP Jindal Global University, Professor Rajkumar, Vice Chancellor RV University, Professor Y.S.R. Murthy, principals and academicians from law colleges, senior partners from law firms, and all dignitaries present here in August gathering. I consider it to be my proud privilege to express my gratitude to all of you for this seminar on the role of judiciary in protecting the rule of law and promoting access to justice under the India-US Law and Justice Forum, jointly organized by RV University and Jindal Global University. On behalf of RV University, we seek to express our sincere gratitude to all the distinguished judges and academics from the US. Your august presence indicates the importance of this event. Though at the international level, our systems may differ, but the challenges faced by the judiciary at national and global levels are more or less common. The intellectual deliberations today only reiterate that we are united in our steely resolve in protecting the rule of law and promoting access to justice. I'm deeply thankful to Professor Rajkumar, Vice Chancellor, Jindal Global University, and his team for initiating the idea of organizing this joint seminar for the benefit of all and for the development of judicial and legal practice. We thank Professor Dwarika Anial, Pro Vice Chancellor, Executive Education, RB University, in absentia, for his support in making this event a successful one. Our sincere thanks to Professor Y.S.R. Murthy, Vice Chancellor, RB University, for guiding us at every step of this event. I would take a slight break here, thanking Professor Raj for allowing Professor Murthy to be at RB. It feels like as if we work with Jindal. Thank you so much. I also thank our colleagues from the School of Law and our entire team from the administration for the untiring effort which has culminated into today's event to be a success. Last but not the least, we wish to thank each one of you in the audience for being a part of this important deliberation. Thank you, one and all.
Thank you, Professor Arpita. This marks an end to our deliberation. The two sessions were lively and interesting. I request everyone to join us for lunch. Requesting our colleague Shashidhar to kindly escort the guests.
Very well.